Good morning, Judge.
Good morning, Judge.
Good. All right. Are we all ready to continue?
Yes, my lady.
Good. All right. Let's start by introducing ourselves and putting ourselves on record on behalf of the plaintiffs.
Georgiadis with Khan. I'm Georgiadis, and my junior is Khan, my lady.
Thank you, Mr. Glendon. It's Mr. Georgiadis, Mr. C. Georgiadis, right?
That's right, my lady.
C with. Oh dear, we've just had load shedding.
Does that mean we're not going to be online?
No, I'm way ahead of them. I'm using my router, so it's fine. Thank you. So it's Mr. Georgiadis with Ms. Khan, right? Advocate J. Khan. And okay, for the respondents.
It's the first to sixth defendants, my lady. It's Glendinning.
Mr. Georgiadis, you're appearing, I take it, for both the first and second plaintiffs.
I am, lady. We are, my lady.
Okay, good. And the rest of the defendants are not participating?
No.
Good. All right. Good, gentlemen. Let me just say a few housekeeping rules. I've read your papers. I've read the heads. So it's not really at this point necessary to go through everything, but let us just set what it is. It's all the preliminary issues as I understand it. It will be the point in limine raised by the defendants that there's no cause of action against the fifth and sixth defendants. That's the first one. And then the 2 points raised by the plaintiffs, that is the jurisdiction of the tribunal to hear a counterclaim, and then the prescription of both the counterclaims.
That's right, my lady.
Okay, so those are the preliminary issues. Mr. Glendinning, are you in agreement?
I am, my lady. Just from a housekeeping perspective, should I commence with the first point, and then thereafter should my learned friend then obviously reply, and then commence with his points?
I think that would probably be the logical flow of the way to do it, seeing as the one preliminary point comes from the defendants and the other two from the plaintiffs. So let's start with you, and then we'll go on to Mr. Georgiadis.
Thank you, my lady. My lady, as set out in the background section of my heads, which start at page 0542 of the case line bundle, do you have the case line numbering, my lady?
Well, what I've done is the third file in this matter, yes. I do have the case line numbers, but I've also physically marked your various heads.
Thank you, my lady. Then
you are looking at the one with regard to the cause of action, the background section.
The background section, yes, my lady.
Mm-hmm.
This matter is concerned with disputes that are associated with the construction of the new Vosloorus Hospital taxi rank, and a claim by the plaintiff that as a result of the conduct of the first, second, third, and fourth defendants, the second plaintiff suffered a loss of some 1.973 million.
Which paragraph are you reading? That are you reading from the first paragraph?
Yes, my lady. Okay. Well, I've summarized it. So
yeah.
Yes. At paragraph 28 of the plaintiff's particulars of claim, the plaintiff states that it will be just and equitable that the first, second, third, and fourth defendants be ordered to pay to the second plaintiff this amount. Now, my lady, the basis in which the plaintiffs plead their claim, now that's set out at paragraph 4.3 of my heads. And that's page 5410 of the case on numbering.
Just give me a minute.
Sure.
Paragraph 4.3, you say?
4.3, yes. I'm not going to go through all the sub-paragraphs. I'm just
no, it's not necessary. I think, you know, so I'm so sorry to interrupt you, but just so that, you know, we're clear. As I said, I've read the papers. If there's something you especially want me to pay attention to, or you want to highlight, or for instance, something new might have cropped up after, because I see you've done your heads in May of this year.
Yes.
So, you know, obviously if there's something that has cropped up and which you think ought to have been included in your heads, it's those things that I would need to direct my attention to.
It's just one of the things I want to emphasize. And obviously, the first thing was that the first to third defendants were represented by the fourth to sixth defendants. So it's the represented portion that I want to emphasize, as opposed, and I'm going to be differentiating between representation and knowledge. And importantly, it's the fourth defendant acting in his personal capacity who, as a member of the first and third defendants, who issues a tax invoice in that. Unfortunately, the fourth defendant is actually now passed. He had COVID.
Yes, I believe so.
But it's the fourth defendant, not the fifth and the sixth. And it was on this basis, so it's pleaded that it's the first to fourth defendants fraudulently, deliberately, and intentionally submit the invoice to the second plaintiff. So to mislead and to give rise to the cause of action. And as pleaded, it's quite clear there's a valid cause of action pleaded against the first to the fourth defendants. Importantly, then, and the principles are trite, but obviously from the defendant's side, while we represent the first to the sixth defendants, I think for purposes for ease, I'm just going to call them the defendants. Insofar as we say that there's no cause of action pleaded, the defendants accept that we've got to show on any possible version no cause of action can arise, and that the plaintiff's particulars are correct. So that's trite. The laws, I've set it all out. I'm not going to go through that at all.
I think both of you have, you know, and it's quite clear. There just maybe one or two questions arising that I might have, but I think both of you have set out the law quite clearly.
Yes, my lady. Importantly, then, at paragraph 5.1 of my heads, where we look, because the plaintiff's cause of action is based on fraudulent misrepresentation.
Sorry, what paragraph, Mr. Glenn?
Paragraph 5.1, that's 05412. And here we see obviously the elements that come from amblers, which is a representation, as opposed to somebody representing. So it's a representation which is untrue, and which at all material times you know it's untrue, or there's no genuine belief. So that's where it comes to this intention and this knowledge. And my lady, that's what we say is so important in this. Now, the pleadings link the representation to the first to fourth defendants, so as to establish a valid cause of action. But they do not set out a basis in which the representation can give a rise to claim against the fifth and sixth defendants. Importantly, no knowledge is ever pleaded to bring a valid claim. And my lady, what we say, that's one of the facta probanda. You know, that's an essential averment. The plaintiffs wouldn't even be able to lead evidence now in that regard, because if they don't plead that, because obviously the defendants aren't required to answer in their plea. And should the plaintiffs then try to lead evidence in relation to the knowledge of the fifth and sixth, that would come up, that would lead to an objection, because that hasn't been pleaded. And important, so there was a Lillikraf Wassenaar case I quoted.
And just give me a minute. Sorry, give me a minute. Which case was that?
This is Lillikraf Wassenaar and Partners versus Pilkington Brothers. My lady, we have at section 55, we've uploaded all the cases to make it easier for you.
Mm-hmm.
And at PP 351 of that case, what they say is, because it's a delictual claim, obviously this is fraudulent misrepresentation.
Mm-hmm.
It is trite law to succeed in such a claim, a plaintiff must allege and prove that the defendant has been guilty of conduct which is both wrongful and culpable. So it's the conduct, it's the act. So there's something positive required. And that's what goes. It's not merely that I represent the first to the third defendant, be it as a member or as a director. And my lady, I submit that stands to reason. One can just imagine you can imagine a listed company where you have a board of directors, and it could have a huge turnover. The directors delegate to individuals. Now, what those individuals do, the directors may not necessarily have knowledge. And that's why my lady said, my lady, what we had said in my heads, what I'd said in my heads was, what is necessary then is to bring some nexus. What the plaintiffs could have done is they could have pleaded an actual misrepresentation made by the 5th and 6th. They could have pleaded for some basis that the corporate veil needs to be lifted. They could have asked for pleaded vicarious liability. These are just some examples, but there needed to be some nexus, which isn't pleaded. Now, my learned friend, in his heads of argument, he relies on the fact that the 5th and 6th defendants represent the entities, which is common cause. That's accepted. But my lady, once again, what to emphasize, just because I represent a juristic entity, that means then my acts are imputed on the juristic entity, not the other way around, not automatically at all.
But just to explore that and that particular idea, juristic entities are not the people who do the things. It's the human beings, who are the minds behind what the juristic entity does. So by representing them and being involved is not your knowledge or
But my lady, the important thing you said is about being involved. Now, what happens if I'm not involved? Remember here, so the way the plaintiffs plead it, they say the 4th defendant's involved. The 4th defendant does everything. Now, if the 5th and 6th defendants aren't aware of the conduct of the 4th defendant, and my lady, I deal with this in my supplementary heads and the actual section of the Closed Corporation Act that where the liability against a closed corporation can then actually be imputed to the members.
Sorry, Mr. Glendon, and you say you file supplementary heads because
Yes.
I'm not in receipt of them.
You should have, my lady. They're at page 05469 of the case on bundle. They're short, and I have to go through those to 05476.
So 05469.
Yes, my lady.
To 76.
76, yes.
All right. Now, because I don't have them, but I'm sure Ms. Mashitisha will send them to me at some stage. That's fine.
Okay, my lady. So then, my lady, and if we might get your email, my attorney says you can also email them to you if that might be easiest.
Yeah, that's fine. Ms. Mashitisha will do so.
So, my lady, my learned friend relies on section 54(1) of the Closed Corporation Act, which talks about the powers of members to bind the closed corporation. But as I say, my lady, all that says, so subject to the provisions of this section, any member of a corporation shall in relation to a person who is not a member and in dealing with a corporation be an agent of the corporation. So that is agency. And then 54(2) says an act of a member shall bind a corporation whether or not such act is performed for the carrying on of business of the corporation unless the member so acting has in fact no power to act for the corporation in the particular matter, and the person with whom the member deals has reasonably to have knowledge of the fact that the member has no such power. So, my lady, that section 54 of the Act, which, as I say, links the when a member does it, the closed corporation becomes liable, and you can't then argue that the closed corporation isn't liable. Importantly, for fraudulent or reckless carrying on of the business, that's section 64 of the Closed Corporation Act. And what section 64 says, liability for reckless or fraudulent carrying on of business of the corporation. Point 1, 64.1. If it at any time appears that the business of a corporation was or being carried on recklessly with gross negligence or with the intent to defraud any person or for any fraudulent purpose, a court may, on the application of the master or any creditor, member or liquidator of the corporation. Now, important this section, declare that any person who was knowingly a party to the carrying on of the business in any such manner, so it's a knowingly a party, shall be personally liable for all or any of such debts or other liabilities of the corporation, as the court may direct. And the court may give such further orders as it considers proper for the purpose of giving effect to the declaration and enforcing that liability. And my lady, by submission, that makes sense. If I'm knowingly aware that, as I say, fraud is going on, one then would become liable. You can't turn a blind eye. But in instances where, as I say, where it's pleaded, well, it's the fourth defendant, and obviously we're taking everything as correct. There is a counterclaim, and there is an answer to. But for purposes of the exception, if we take it as correct that the fourth respondent had fraudulent intent, that doesn't. What is needed now is to show that the fifth and the sixth the defendants knowingly were party to this. In other words, they were aware, they condoned it, whether they should have been aware, etc. But that is what's needed to be pleaded, my lady. That's my submission. Not simply that I'm a member. And it stands to reason, because even closed corporations can be very substantial and can have many different individuals, etc., working for it, delegated authorities, such that the knowledge of fraud or reckless trading then is what's required to impute personal liability. And that's, my lady, my sort of final submission almost is that for the plaintiffs to have pleaded a valid cause of action against the fifth and sixth defendants, they needed to plead that these defendants were knowingly a party to the carrying out of the business in a fraudulent manner. We have asked that the matter be dismissed against the fifth and sixth defendants. As this is really an exception, what would probably be the correct course of or approach would be that the plaintiffs be given opportunity to reconsider the matter, and if they wish to amend their pleadings, to be allowed to amend their pleadings. I do think at the end of the day, justice mustn't just be done; it must be seen to be done. So the fact that this is now formulated as a special plea as opposed to an exception, I do believe that, as I say, that if my lady's with me, that the plaintiffs be given the opportunity to consider the matter, and that you don't just simply dismiss the case. If there was actual knowledge and they want to plead actual knowledge, that they should be given that opportunity. My lady, those are the submissions, unless you have any further questions.
No. That was just that issue of the representation, yes. But we'll get to other things when we're dealing with the plaintiff's points in limine.
Thank you,
but with regard to your submission, it was just the representation and what your view is as to why you say the fact that you were a member does not mean that we can't impute liability to you. And I think you've covered that.
Yes. We're not saying you can't impute. We're saying it's the knowledge that then gives rise to the imputing. There could never be a blanket, and even that section of the Closed Corporation Act recognizes when you can impute the knowledge and then make them personally liable. Thank you, my lady.
Thank you. Thank you, Mr. Georgiades.
Thank you, milady. Milady, I'm somewhat perplexed by my learned friend's argument. Not his argument on his heads or on the substance of his argument, but I understood this to be a special plea and a point in limine. My learned friend seems to now refer to it as an exception. And then he also says that if it's a good exception, then we must be given an opportunity to amend. I was going to commence my argument with that very point, milady. There's two points that I wish to make on two submissions that I wish to make, that we wish to make on that point, and that is firstly that a point in limine doesn't have any status at all in terms of the rules. In terms of the rules, one can either take a special plea or one can take an exception. Now, it's obvious that they haven't utilized the proper provisions of Rule 23 to take an exception. What they have done is referred to the points in limine at the outset of my learned friend's heads. If one looks at the first page of his heads, it seems to be in the introduction at page 054-2. It says in the introduction that the first to 6 defendants hereinafter the defendants have raised a special plea in terms of which the defendants allege that the particulars of claim of the first and second plaintiffs do not disclose a valid cause of action. Now, my argument was going to be, and it is still, that cannot be raised by way of a special plea. That can only be raised by way of an exception. And I haven't included this in my heads, and my lady, I'm indebted to your ladyship for saying that we can now include submissions in our heads that were not that have not been raised in our heads, and I'm thankful for that. My lady, I want to refer your ladyship to Herbstein and Van Vincent, the civil practice of the High Courts of South Africa, the 5th edition, volume 1.
Just a minute. I wish I could write as fast as you speak.
I apologize, my lady.
A 5th edition?
Of the civil practice of the High Courts of South Africa, Herbstein and Van Vincent.
Yes, give me the page reference.
Page 600, my lady.
Thank you. Yes.
Now, if I can be permitted to read to your ladyship, it says that if you just commence on page 599 at the bottom, sorry, I apologize. The essential difference between a special plea and an exception is that in the case of the exception, the excipient is confined to the 4 corners of the pleading. The defense raised on exception must appear from the pleading itself. The excipient must accept as correct the factual allegations contained in it and may not introduce any fresh matter. Special pleas, on the other hand, do not appear ex facie the pleading. If they did, then the exception procedure would have to be followed. Special pleas have to be established by the introduction of fresh facts from outside the circumference of the pleading, and those have to be established by evidence in the usual way. So what it's saying, my lady, is that there's a fundamental difference between an exception and a special plea. Now, my learned friend seems to have raised an exception by way of a special plea, and the two don't go hand in hand. It's either the one or the other. If it's a special plea, as he says in his heads, then it must be dismissed. It should only be raised by way of exception. Now, why the fundamental difference? The fundamental difference being that if it's an exception and the exception is good, then like he says, we should be given an opportunity to amend.
You did try to amend, but you abandoned it, didn't you?
Yes, we did, my lady. But now that it's come to the fore, now that we've come to the gallows, and we're on the steps of or on the precipice, then we should be given an opportunity. But I'm going to argue to your ladyship that we do implicate the 5th and 6th defendant, as I do in my heads, as we do in our heads. Now, my lady, I also want to refer your ladyship to a case that makes the same point that was made in Herbstein and Van Vincent. In fact, it refers to Herbstein and Van Vincent. And I apologize. The passage is at the case of South African National Parks versus RAS, R-A-S. 2002, bracket 2SA, 537. It's a decision of the Cape Provincial Division.
Yes.
What it says is, again, against the letter H, at page 540, against the letter H, it says, it appears from South African case law that where it is apparent, ex facie the particulars of claim, that a plaintiff does not have locus standi, the defendant may take an exception rather than file a special plea. Then there's some reference to a case with the Muslim Judicial Council, and it's a quote from a case that I wish to read you to your ladyship. It says, the essential difference between a special plea and an exception is that in the case of the latter, the excipient is confined to the four corners of the declaration. Exactly word for word what's contained in Herbstein and Van Vinsen. The defense he raises on exception must appear from the declaration itself. He must accept as true the allegations contained in it, and he may not introduce any fresh matter. Special pleas, on the other hand, do not appear ex facie the declaration. If they did, the exception procedure would have to be followed. So what my learned friend in fact raises is in essence an exception, but he wants to raise an exception, but he's gone about it the wrong way with respect and brought it by way of a special plea or a point in limine. On that basis alone, my lady, the special plea should be dismissed with costs. But even if we're wrong, even if we don't implicate, and I'll come to that in a minute, and my lady's read my head, so my lady knows how the particulars of claim seek to implicate the fifth and sixth defendant. What we say is, even if we're wrong and we don't implicate, the case shouldn't be dismissed against the fifth and sixth defendant. And as my learned friend says, we should be given an opportunity to amend. And I'm indebted to him for that. Then I refer my lady to our heads at page 51. It's 054-51.
Sorry, just repeat that for me, please, Mr. Georgiadis. 054?
054-51.
51. Paragraph?
Paragraph 14.1 to 14.3. This is the summary of what's said in the plaintiff's particulars of claim and pertaining to the fifth and sixth defendant. At paragraph 9 of the plaintiff's particulars of claim, the plaintiffs indicate that the fifth defendant is cited herein in her personal capacity and in her capacity as member director of the first and third defendants. The next paragraph, at paragraph 10 of the plaintiff's particulars of claim, the plaintiffs indicate that the sixth defendant is cited herein in her personal capacity and in her capacity as a member director of the second and third defendants. Then in the next paragraph, more importantly, and perhaps to be underlined, at paragraph 17 of the particulars of claim, the plaintiffs plead that at all material times hereto, the first, second, and third defendants were represented by Jacob Pungula, who is the fourth defendant, the deceased, Veronica Mabena, who is the fifth defendant, and Joy Siale, who are the sixth defendants. So if they at all times represented the CC or the company, then everything the company did should be imputed to them. Now, what's staggering, in paragraph 16 of our heads, we say, in addition, the defendants admit that at all material times hereto, the first, second, and third defendants were represented by the fourth, fifth, and sixth defendant. So they admit that at all material times, the first, second, and third defendants, the entities, in other words, were represented by their directors, by the fourth, fifth, and sixth defendants. And of course, then we say at paragraph 18 of our heads that the fifth and sixth defendants as members will have actively it's a logical inference that they would have actively participated in the fraud perpetuated against the plaintiffs. They admit that the canopies, all the defendants admit that the taxi canopies were not delivered, milady. Yet they submitted an invoice. And then we rely on Section 54 of the Close Corporation Act. That submission is made at paragraph 19, and it's in footnote 7 of our heads, where we quote, subject to the provisions of the section, any member is a member of the corporation shall, in relation to a person who is not a member and is dealing with the corporation, be an agent of the corporation. So it deems that person, that member, to be an agent of the entity for the purposes of the business of the corporation. So, my lady, that in a nutshell leads to the fact that the conclusion, the logical conclusion that the conduct and actions of the first, second, and third defendants, in other words, the entities, are imputed to the fifth and sixth defendants by operation of law. And then it's up to, with respect, then it's up to my learned friend, or rather the fifth and sixth defendants, to plead that they were not aware of what the companies were doing. That, in other words, the company was on a frolic of its own, or any one of its other members or directors were involved in the fraud, or in the knowledge that the taxi canopies knowingly had not been delivered and had been invoiced. Those are our submissions, my lady, on that issue. If I can then move to the other points that we've taken, the special pleas.
All right. Now, well, let me see if Mr. Glendinning has a reply to what you've said, and then we move on.
As your ladyship pleases.
Mr. Glendinning.
Thank you, my lady. I think my first point in reply will be that the defendants obviously had an election in relation to an exception or a special plea, and the law was tried there. As I said, insofar as you're on a special plea, and if you're with us, well, then the correct point, the correct approach would have been to dismiss it. But really, it was a case of looking at justice that I had said that let's provide the plaintiffs with a further opportunity to reconsider it. My lady, insofar as my learned friend then suggests that, well, Section 54 and the representation then is what creates the knowledge. If that was so, my lady, then my submission would be that Section 64 of the Close Corporation Act would be superfluous. And my lady, the authority there's also tried, and I don't know it offhand, I can potentially provide it, but that the legislation there's no provisions that are superfluous. So Section 64 was needed in order to differentiate between representation and actual knowledge, so as to impute the actual knowledge on the people who represent. It's not, one doesn't flow automatically, because I say if it did, you would not have Section 64, and Section 64 does exist. I think, my lady, yeah, those are my further submissions in reply. Thank you.
Thank you. Right, then we move on to the plaintiff's points in regard to jurisdiction and prescription. Mr. Georgiades.
May it please your ladyship. My lady, the point about jurisdiction is related to the counterclaim that is brought by the defendants. And in that regard, we make two chief submissions, and those can be found in paragraph 23.1 and 23.2 of our heads.
Just give me a minute. Uh, 23, you say?
Yes, paragraph 23 of our heads at 054-55.
Mm-hmm.
And there we say that the Act, the SIU Act, was enacted for the purpose of investigating serious malpractices or maladministration in connection with the administration of state institutions, state assets, and public money. And we've emphasized state institutions, state assets, and public money, as well as any conduct which may seriously harm the interests of the public. And we say that's the purpose of the SIU Act. And the counterclaim doesn't have anything to do with that. The counterclaims, there's two counterclaims. That's the first point, my lady.
Mm-hmm.
Milady, then we have what's called there's two contracts that involve the counterclaim. The one is the Phosphorus contract, and the other one is the Blue Gum View contract. And we say that none of our claim has anything to do with the Phosphorus, sorry, I beg your pardon, with Blue Gum View, with the Blue Gum View contract. And therefore, there's no list between the plaintiffs and defendants in this regard. So even if we're wrong, and the counterclaim is the court does have jurisdiction to entertain the counterclaims, or the one counterclaim would be allowed, and that's the Phosphorus one, not the other one in relation to Blue Gum View. Now, my learned friend says...
Sorry, just give me a minute.
I apologize, my lady.
Mm-hmm.
My lady, then, again, without burdening your ladyship unnecessarily in this argument, what we do is, at paragraph 25 of our heads, we set out the purposes for which the SIU Act was enacted. And I'm only going to read it once. It's repeated quite often in our heads in some sort of different guise. But really, it can be found at 25.1 to 25.3 at pages 054-56.
Mm-hmm.
And one is to provide for the establishment of the SIU for the purpose of investigating serious malpractices or maladministration in connection with the administration of state institutions, state assets, and public money, as well as any conduct which may seriously harm the interests of the public. Well, the counterclaim's got nothing to do with that. Secondly, to provide for the establishment of special tribunals so as to adjudicate upon civil matters emanating from investigations by the SIUs. And then thirdly, to provide for matters incidental to the two purposes set out above. So the counterclaim has got nothing to do with public money. It's got nothing to do with investigating the serious offences that the Act was enacted. But that doesn't mean But that doesn't mean that it's the end of the road, or that the doors of natural justice or the Constitution in terms of Section 34 are closed to my learned friends' clients. They can certainly bring an action in the High Court for what they claim is the repayment of retention money.
Mhm.
And then we refer to various sections in our heads, my lady, and I'm not going to repeat all of the sections. Your ladyship can simply read section 2, bracket 2. Your ladyship can read section 8, bracket 2, which I'll just repeat for purposes of this argument. It says, the special tribunal shall have jurisdiction to adjudicate upon any civil dispute brought before it by the SIU or any interested party as defined by the regulations. And then importantly, we've emphasized this emanating from the investigation by such special investigating unit. Now, the counterclaim for the payment of retention money has got nothing to do with the investigation relating to taxi canopies or money that was paid over as a result of a fraud.
Mhm.
And then in paragraph 39 of our heads, we say the following. It's at page 054-63. Having regard to the aforesaid, it is apparent that the SIU was created and designed exclusively for the recovery of any damages or losses suffered by a state institution and the prevention of potential damages or losses which may be suffered by such a state institution. The SIU Act does not make provision for the institution of action by members of the public, which explains why the defendants have not instituted action in this court previously. A litigant is defined as an applicant or the plaintiff and shall include a party with a direct and substantial interest in the civil proceedings brought before the tribunal.
Mhm.
Now, one can imagine if the defendants had brought such an action in the SIU, clearly the tribunal would not have any jurisdiction. And then we refer sorry, my lady. And then we refer, my lady, to the case in paragraph 40, this case of Special Investigating Unit and another versus Caledon River Properties, a decision of Her Ladyship Justice Modiba. And we quote paragraphs 47 and 48. And those say that, and I quote, a glaring feature that the special tribunal shares with the magistrate's court is its lack of jurisdiction in the general sense. This is consistent with, over the page, the ad hoc nature of the special tribunal established for a specific purpose. The legislative intent is not to create another high court, but to create a focused, specialized court of similar status to the High Court, to deal only with civil litigation emanating from SIU investigations. So I pause there to say the counterclaim, the retention money, has got nothing to do with civil litigation emanating from the SIU investigation. And then to complete the quote, it is notable that the orders which the special tribunal may make with its jurisdiction are not limited by statute. Section 8.2 affords the special tribunal the power to make any order to give effect to any ruling or decision it has made. In this regard, there is a measure of inherent jurisdiction not enjoyed by the magistrate's court, which the special tribunal enjoys over civil litigation instituted by the SIU in the special tribunal, hence reference above to the lack of inherent jurisdiction in the general sense. And then we say in paragraph 41, the uniform rules of the High Court speak to the procedure to be followed in the event the SIU is silent and does not confer jurisdiction on the special tribunal to hear its counterclaim. Now, it's correct that in the rules it's spoken about as a that one can bring a counterclaim. But we submit only when it has to do with the investigation. There's no nexus here between the investigation and the lack of payment of the retention money, the alleged.
Referring to Rule 13D.
13.
Yeah.
Yes, my lady. The whole purpose of the Act.
So if it had to do, for instance, if they were raising some sort of defense with regard to the canopies, you'd say that would be allowable.
Correct, correct. And then, my lady,
Thank you.
even if there's a list, if your ladyship finds there's a list or a valid counterclaim in regard to the Phosphorus contract, that can't be said of the Blue Gum View contract. And we deal with that in paragraphs 44 to 50 of our heads. At pages 05465 to 66.
Paragraph 40.
45?
Oh, yes.
Sorry, 44. I apologize. 44 to
yes,
50.
I see that. Mm.
Yes.
Mm-hmm.
And that's the end of my submissions regarding that, the counterclaim, my lady. Unless your ladyship has any questions.
No, you've actually dealt with, the only one I had was, what is your response to, I mean, I figured that from your heads and so on, but I just wanted you to clearly articulate what your view was with regard to Rule 13D, because that was pointedly raised by the defendants, yes.
Yes, my lady. My lady, then lastly, the issue of prescription. I don't think my learned friend will contend that 3 years has elapsed since the cause of action arose. The 3 years in relation to the Phosphorus, and I deal firstly with the Phosphorus contract, that took place in 2016. That cause of action arose in 2016. But what they say in response is that the second plaintiff, the Ekurhuleni, in other words, had not issued a certificate of completion, which is a condition precedent to the entitlement to payment of the retention money.
Mm-hmm.
And then they contend that the retention money entitlement can't prescribe because it first needs to arise.
Mm-hmm.
But with respect, that can't be a serious contention, because if the reason why the certificate was never issued is because of the fraud relating to the taxi canopies. So the cause of action will never arise in those circumstances. We'll be waiting forever for that certificate of completion. They don't ask for a certificate of completion. They don't bring a case to say they want the certificate of completion because of the fraud. The contract was simply never completed. So no certificate of completion can ever be issued. So the logical consequence of that is that the claim must have arisen in 2016 and not now, and not in the future. So accordingly, it's prescribed.
Mm-hmm.
And then in relation to the second claim, the prescription of the Blue Gum View contract, the same argument can be made if the court's inclined to deal with the Blue Gum View counterclaim.
Mm-hmm.
So, my lady, we ask for an order that the counterclaim be dismissed either on the point that on the special plea that the court doesn't have jurisdiction, the two counterclaims, sorry, or on the issue of prescription. That's either or. If one of those pleas are good, then their counterclaim is dismissed with costs. And we ask for costs of two counsel. We're so employed.
Okay.
Those are my submissions. Those are our submissions, my lady.
Thank you. What do you say about their entitlement to have this counterclaim or these counterclaims adjudicated on if the entitlement hasn't arisen?
Which entitlement, my lady? The
entitlement to the payment of the retention money.
Well, we say that the entitlement can never arise because the certificates were never issued or can never be issued because of the fraud. So therefore they've prescribed. The counterclaims have prescribed.
Well, they say pointedly in their heads that the debt is not due. Can you claim in respect of a debt that is not due?
No. No. And in fact, it's their pleading that's acceptable.
Thank you. Are those your submissions, Mr. Georgiades?
Those are our submissions. Thank you, my lady.
Thank you. Mr. Glendinning, your reply.
Thank you, my lady. In relation to the jurisdiction point, I'd first like to start at the point that we're dealing with construction contracts which are indivisible contracts. My learned friend looks at the canopy and tries to sort of take this out of a construction contract. This was a contract for the supply or for the construction of a taxi rank.
Now, Mr. Gunning, before you actually go forward, this issue of indivisible, while there might be an authority to do investigations in respect of two contracts, can they ever be, that is something I could not follow. Can they ever be indivisible where it's two separate contracts, two separate locations, 2 different years, in fact?
Okay, my lady, there are 2 separate indivisible contracts. We can't, there's not one indivisible contract. Our submission in relation to Blue Gum View was there was one proclamation. So perhaps let's clarify that. So I'm not saying not submitting that the Blue Gum View contract and the fossil risk contract are one indivisible contract. That's not so.
Okay.
They're 2 separate indivisible contracts.
Correct. But then it brings me, because I don't want you to argue on the point any further if we can resolve it at this point. If that is the case, then is there any claim in respect, in the plaintiff's particulars of claim, in respect of the Blue Gum View contract? Is there any claim at all?
No, my lady, that's common cause is not. Yeah. Our submission was that because there was one proclamation, and in light of, and what I'm going to do is I'm actually going to take, it was a case, it's also the Calendar River Properties case that I discovered in research for the oral arguments, which dealt with a few things, and perhaps, okay, so that case, it's Special Investigation Unit and another.
Sorry, give me a minute.
It's at 055197. So we've uploaded it.
Okay, just give me a moment, please.
No problem.
All right. So you were talking about the Caledon River. Case.
It's another further judgment in the Caledon River case. So the reference I have is it's Special Investigating Units in another versus Caledon River Properties in another. GP 17 2022 ZAST 6 8 March 2022.
Yeah.
Now that was the Honourable Justice Deba.
Yeah.
Now at paragraph 7 of that judgment, what she says, the tribunal dismissed the points of law and found, because this is the question, whether the tribunal had jurisdiction. Normally it's the defendants who try to challenge jurisdiction. And what she found, the tribunal dismissed the points of law and found that the tribunal is a court of law with the status of the High Court as envisaged in Section 166E of the Constitution. So it has the status of a High Court once we have a proclamation and once there's an election by the SIU to refer a matter to the tribunal. If nothing's ever referred to the tribunal, my lady, then I accept. The defendants would never have jurisdiction of their own to go and bring a claim in the tribunal. My lady, my submission is that once the election is made, because remember it's not just the SIU, it's also the actual public body, the second plaintiff here being Ekurhuleni, who has an election. They can say, well, do I go to use the tribunal or do I use the contractual mechanisms? And they elect. Going where this case perhaps is more important is this case actually dealt with counterclaims. It's the first time. And at page 26 of that judgment, what it says, pursuant to the tribunal's direction.
Page or paragraph 26?
Oh, sorry, paragraph 26, my lady, apologies. So, pursuant to the tribunal's directives, the SIU filed a declaration praying for the repayment of amounts of some 21 million and 1.8 million prepaid. This is to Prof Team and Caledon River. The SIU alleged it was irregular for public works to have made any payments before the defendants performed in terms of the contract. So that was the claim. And then in the alternative, the SIU sought an order divesting the defendants from the profits. Now, from paragraph 28, the defendants made a counterclaim. So that the defendants filed separate pleas and counterclaims. In their respective counterclaims, they seek as a just and equitable remedy an order in terms of which the rights vested in terms of the invalid contracts remain vested, and Public Works is ordered to make payment to the defendants of the balance due in terms of the contract. At paragraph 29, Prof Team also pleaded elaborately regarding the difficulties it encountered while implementing the contracts under restricted lockdown conditions, the risks it was exposed to, and the measures it resorted to ameliorate the risks. Then at paragraph 30, in the alternative, Prof Team pleads that due to the costs involved and the risks in which it is exposed, justifies, in addition to the amounts already paid to it, an order that Public Works paid to it the amount the tribunal found to be just and equitable. So they also had their counterclaim, further one. Now, in deciding the counterclaims, that appears from paragraph 45. Now,
45 of the judgment, or your
paragraph 45 of the judgment. And so paragraph 45 says, Prof Team has not established on the facts exceptional circumstances that justify a departure from the no profit principle. Therefore, it has not made out a case for the tribunal to allow them to retain all their vested rights, as was the case in Jujima. what happened in this matter was neither party led evidence. So there was no evidence led. And the Honourable Judge Justice Madiba found that evidence needed to be led. So at 46, she said an exception to the no profit principle was applied in Jujima due to the peculiar facts of the case. There, the Constitutional Court ordered that despite a declaration of invalidity, to prevent an unjust outcome, Jujima should not be divested of the profits it would earn from the impugned contract. Jujima had been induced to agree to the termination of a valid contract in exchange for an invalid contract. The Constitutional Court allowed Jujima to retain profits earned from the latter contract to compensate it for the loss it would have suffered as a result of this inducement. Then at paragraph, therefore the plaintiff's main claim stands to be dismissed, the alternative claim stands to be upheld. To the extent that the defendant's counterclaims are consistent with the plaintiff's alternative claims, they are nugatory. To the extent they are not, the defendant's counterclaims stand to be dismissed for the reasons set out in paragraph 45 and 46. So the counterclaims weren't dismissed because of no jurisdiction. They were dismissed because they weren't proven. So, my lady, my submission here is that this case now is direct authority, that the tribunal does indeed have the jurisdiction to consider counterclaims in relation to the projects. Again, and this is why I wanted to go to the indivisibility. If you look at the Fossler's contract, it's a contract for construction of works, including a canopy. If you look at the defendant's plea, what they say is there was the canopy wasn't supplied. The reason it was certified, and ironically, if you look at their plea, they will say, well, we're trying to be nice. The Ekurhuleni needed not to lose their budget. So they said, please, it'll be over-certified, and we'll catch up in later certificates. So there'll never be a risk. And one of the things I'll come into the next stage, if you look at the defendant's plea, 18 certificates are issued. Now, the canopy, and I'll take you there later when we look at prescription, is certified in payment certificate 5. So there's another 13 certificates issued. So it's an indivisible contract where it all then eventually comes out the wash. So part of the very defense of the defendants is that, well, yes, there was a point in time it wasn't delivered. The contract carried on, and eventually it was sorted out. We were paid what we were entitled to be paid, less this retention amount. Now, what my learned friend wants to do is say, look, we're going to take a tiny slither out of this indivisible pie, the canopy. We can only look at that and look at nothing else. And my lady, well, as I say, my submission there is that's absurd insofar as the contracts are indivisible. You have to look at the law.
Let me just stop you there because I am not following that point. Were those canopies ever delivered?
No, my lady, but the canopy wasn't delivered. But my lady, what happened, if you look at the pleadings, they're saying the subsequent certificates, it gets taken out. So you get a payment, because payment certificates are cumulative. So if a payment certificate says, well, the value of the work plus materials is 5 million, maybe. The next one, 6 million, the next one, 7 million.
Yeah, but just if I follow that, then what you're saying is we took out 1.9 million for those canopies, but we made up in the subsequent certificates of payment for work that we did to the value of 1.9. Yes.
So when you get to certificate 18, the canopies are no longer there. They're then gone because it's cumulative. So you look at the total value of the work and obviously less you previously paid. So the defendant's pleadings is, yes, at a point in time, we were overpaid. The reason we were overpaid was the department wanted to spend their budget. But that overpayment got taken out in the wash over the next 18 or the next 13 payment certificates. And that's in trial, that's really what the tribunal will need to have a look at and be saying, well, okay, is that so? We were saying because it's common cause, the overpayment was made. Was it, the real question here is going to be, was it eventually sort of absorbed in the next payment certificate, such that when you got to payment certificate 18, that the Ekurhuleni actually owed about 300,000. So you're going to look at it in the defense, and then my learned friend says, but then if you find that you can't go further and say, well, pay the 300,000. And my lady, as I say, my submission, well, just on practicalities, that could not be. I deal with the objectives of the SIU. We also look at government and the high sort of the role model and the status it must play. Ultimately, it's and then we went to the Constitution and Section 217, which says that, well, government must get fair value. So yes, if government is cheated, they must get their money back. But at the same time, if there is a 300,000 rand overpayment, then or amount still due, that should get paid. And then my lady, then I look at the authority in relation to potential conflicting decisions. If say you had to find there was no jurisdiction, now you would go through and say eventually, well, yes, there is an overpayment of or so there's an underpayment of 300,000 to the defendants, but I don't have jurisdiction to award it. So therefore, no money is owed to the plaintiffs. Now, in another would be adjudication or a court would look at the same matters. They might come to a different decision because they're not bound to you, and that's the very why one would want to look at everything holistically, come to one decision, which then is binding on both parties in relation to this indivisible contract.
Yes, that's exactly the point. I said therein lies your submission about the indivisibility of the contract.
Yes, and my lady, insofar as Blue Gum View, yes, as I say, there is no claim.
Oh, you're muted. I can't hear you.
Am I muted?
Yes. Now I can hear you. Now I can hear you.
I'm not too sure what happened.
It just said about the Blue Gum contract.
Blue Gum View.
Yes, and I lost you there.
My submission is that insofar as the principles in relation to the phosphorus and the principles related to Blue Gum View are largely the same. This is all about sort of this indivisible contract and whether retention should be paid. My lady, my submission, it's expedient for the tribunal to find that jurisdiction. And because there's one proclamation, my submission is that you have the discretion. The moment, insofar as the tribunal is a high court, and there is a proclamation and a matter has been brought before it, my submission is that the tribunal should look at everything holistically and decide, well, does it make sense to assume jurisdiction? And that you do have the authority to do that based on the fact that there is one proclamation.
And that's the point I started off with when I didn't understand the indivisibility, but I do with regard to the phosphorus contract. But as far as the Blue Gum View contract is concerned, on what do I make any finding? Because it's not part of the cause of action. It's not at all discussed or raised in the particulars of claim. There's nothing before me in terms of the facts and logistics of that contract for me to even make a finding, other than the defendant's submission that it was a completed contract. I don't know whether the municipality took occupation, because obviously even if a defects liability date is not set and they take occupation before the defects are rectified, then the date of occupation becomes the effective date. But there's nothing before me, and the plaintiffs have not had an opportunity really to deal with that, other than to say, but why are you bringing that now? We didn't investigate it. We don't know what the outcome is. So I'm not sure on what basis I can even deal with that contract.
Remember, my lady, in terms of proclamation, that the SIU did investigate that project. They decided not to institute any claim. So there's one proclamation. If there were two proclamations, my lady, then I would say one could never. Remember, the onus is always going to be on the defendant to prove its case.
Yeah.
So the defendant would need to lead evidence, and the Ekurhuleni is there as a second plaintiff. So they're there as well. My lady, are you frozen? Oh, no, sorry.
No, I'm still here. Am I so still?
So the defendant has to prove its case. if it doesn't prove its case, it will lose. It's exactly what happened in the Caledon River case, where no evidence was led. There would have to be a trial. The defendants would need to lead evidence in relation to both. Always saying it's very much the self-same evidence that is being led. You've got these contracts where what we're saying, they're indivisible. They were both subject matter to a proclamation. There needs to be a handover. There needs to be a payment certificate which gives rise to a cause of action. They then ask for a fiction of fulfillment, which can only, and it's the fiction of fulfillment that will then start, if you like, the prescription, because nothing was ever issued. But that would happen in trial.
Yeah, but the way I understood the response, well, I'm not going to say that. I'm going to let Mr. Georgiadis respond to what you say, and then I'm going. If he does not touch on the way I understood it, then I'll ask for clarification.
Yes, but my lady, it's simply finding of jurisdiction doesn't now mean that, as I say, the defendants are entitled to their money. They've got to prove their case. If they don't prove their case, they lose. I think. I think in relation to the SIU Act, the purpose, etc., the parties are largely common cause, yes, and the primary purpose will always be to recover monies. So I think we are, but my lady, as I say, my submission there is there are these underlying, if you like, purposes, and one of them is that efficient use of resources, justice is done, etc., etc. I think they have dealt with everything else in relation to that point. And then I just, obviously, it was natural justice and equity where I'm saying one would, and my lady, in the Caledon River case, the Honourable Justice Madiba doesn't say why she finds jurisdiction. As I say, she just assumes it. But I think if you look at the principles I set out about natural justice, where organs of state should act as a role model of propriety, that's Madibeng local municipality, where MEC Department of Education, these all are paragraph 351 of my second heads, where we say that in the management of its contractual relationship, it must ensure that it satisfies the requirements of administrative justice and fairness. And then the 351.3, MEC Department of Police, Roads and Transport, where I say, it is important that governmental institutions respect the rights of those with whom it transacts. And then if the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself and invites anarchy. All these things, I say, would, if you like, lead to my submission that the Honourable Justice Madiba was correct when she said that the tribunal does have jurisdiction to hear counterclaims. Okay. Moving then on to the second P in limine, the prescription claim. I think it's important to have a look at the defendant's counterclaim, and that started, and the payments of retention money, and that starts at 03033, and where they say it's common cause that the JV was appointed on the 18th of February. That's paragraph 50. They set out the contract. I think, yes, in March 2017, they say then the JV was ultimately forced to vacate the project site. As a result thereof, this is in March 2016 at paragraph 53, and was paid the amount of VAT, or was paid the VAT inclusive amount of 541,000 as provided for an interim payment certificate number 18, attached mark annexure JV7. So that's where, as I say, so my learned friend is incorrect when he says that, well, there are no certificates would ever be issued because of the fraud. 13 more were, and obviously that would eventually be shown in evidence. But as I say, it's the reality is that the defendants were paid additional money. And my lady, I'd like to then take you to the actual payment certificate that became the cause of consternation in relation to the canopy and that overpayment, to show, because the the defendant's submission is that the engineer had to certify. That's what gave rise to the cause of action, because without it, he couldn't submit a claim. And my lady, so it's at page 0488 is the payment certificate. And if you could maybe go there, my lady.
Just a minute, just a minute. 04?
88.
So it's bundle 04 and page
88, yes.
Yeah. Okay, I'm there.
So my lady, if you look at the third one, the fourth column, you'll see it says, or fourth line, sorry, certificate number 5 is there on the right-hand side. So this is certificate number 5. Just above it, my lady.
Yes, yes, I've just got it. Let me bring it in front of me. Oh, here we go.
Yeah, because so it says certificate number 5. The line just above it, it's got progress XX. So it's a progress certificate, as opposed to completion or final. Then you'll see
somebody's not muted.
I think it's your registrar, my lady.
Paul, can you mute?
Okay, thanks.
Thank you.
Okay, so it's the line above it, as you see, is made out to EMM. That's the second plaintiff. And then the contractor is Kubwa Kazi Labaka JV. Now, if you go 1, 2, 3, 4, 5, 6, the 8th line, it says the minus retention money 10%. So this is where retention at that point in time was withheld of 315,702. Importantly, the second last line is when it says.
Just give me a minute, sorry. So that will be under that. The bold
under brutto value
of completed work.
That's correct, ma'am. So you see, here's a retention. And then the second last line, it is hereby certified that the above amount in respect of work done in accordance with the specification of the contract and to our satisfaction and of materials on site to be used in the permit worked is now due to the above contractor.
Just a minute.
So it's here where he makes it due. And then I'm going to refer to the preceding page 00487. So it's just one page before. And here it says, I hereby certify that it says 1.973 million, including that, is due to Kubwa Kazi Labaka joint venture for work done and on material supplied in connection with the above contract. Copy of certificate is attached to this letter. So this is what gives rise to the cause of action. That's what then triggers the invoice. And that's the case as pleaded by the defendants. And then he says, well, and then obviously it's also pleaded we've got these 13 further payment certificates. So in terms of that, it's the cause of action is not an invoice. What needed to be done was the engineer would issue a certificate. And the case is pleaded by the defendants, well, it was never done, so we're going to now ask the court to actually go and say, well, now it is done, and that'll then perfect the cause of action and then give rise to the entitlement. So my ladies, so that basically say that, well, the cause of action hasn't arisen. Now, it's not in my head, my lady, but, and again, I'll ask my attorney to upload a case. It's a Supreme Court of Appeal case. It's a funny name, Jugwanth. So Jugwanth, yeah, versus NTN. JUGWANTH versus NTN. It's 2021 ZASCA 114. So, my lady, there in that case, the Supreme Court of Appeal confirmed that with the prescription defense, the onus is on the party raising prescription as a defense to prove prescription. So, my lady, my submission would be at best now, because obviously no evidence has been led, that either, as I said, so best for the plaintiffs, one could say, well, in the long run, you're going to need to lead evidence to show that the cause of action arose at a point in time. There's no evidence before you in relation to the cause of action. So once again, I think to dismiss the prescription defense now might be harsh on the plaintiffs. But I'm going to say that with a rider, what the plaintiffs haven't taken cognizance of is the fact that if the defendant's claim had prescribed, so would the plaintiff's claim have prescribed. The plaintiff almost is relying on a payment certificate. And it's actually the defendant here, almost, as I say, and maybe my lady, besides being counsel, I'm also an engineer and a project manager. So I almost exclusively deal in construction law. It's actually the underlying construction contract that gives rise to everything. So let's say no work was done and it was an overpayment of 1.93 million. The plaintiff would perfect its cause of action when it cancelled the contract, which it does in its replication. And then eventually everything will get determined in terms of the underlying construction contract. But if we look at payment certificates, or if we're looking at prescription, if the defendant's claim goes, so does the plaintiff's claim go. Because obviously the knowledge it also wouldn't have. So it would almost be a hollow victory for the plaintiffs if you had to find that the claim had prescribed, because in the long run, and that's even why when it came to costs, we would say then, have a look at that well, they actually shouldn't be entitled to the cost exactly because of the fact that their own claim is going to get destroyed. Such that my submission there would be that if you had to find the claim was prescribed, that each party would bear its own costs on that basis. That it's a hollow victory. I don't know if there's anything else my lady would want clarification on.
No.
I think then, my lady, those are my submissions. My heads, I think, are quite comprehensive. I always try.
Yes.
So they
are. Thank you.
Thank you, my lady.
Thank you, Mr. Glendinning. Mr. Georgiadis, do you have a reply?
Yes, my lady.
Mm-hmm.
My learned friend says, and quite rightly, they admit that there was no canopy, no taxi canopy. They say, though, you must look at, and now I'm dealing specifically with the point of jurisdiction on the counterclaim. They admit that there's no canopy, but they say, look at the remaining 13 certificates holistically.
Mm-hmm.
So what they want the tribunal to do is get involved in an accounting exercise. If they admit that the canopy wasn't delivered and they were paid for the canopy, they should return the money.
Well, what he's saying is that by way of those 13 certificates, they've worked off that amount that was invoiced for, which they did out of the goodness of their hearts to prevent the municipality losing its budget for that particular financial year. That's the way I understand that argument.
Yes,
so,
but what they're saying then is you've got to look at it holistically. So you've got to look at all the certificates and all the money that was paid, and we want the retention money. Now, that's a commercial, an accounting exercise that shouldn't be done by the tribunal. It should be done by another court, by the High Court, or whatever other forum they choose to sue in.
Mm-hmm.
This forum is about the payment of a certificate or the payment on an invoice that was fictitious and fraudulent. The two are separate, my lady. They can't say, well, then we issued other certificates where you paid and that'll be offset that'll offset the payment for the canopy.
And by implication, offset the fraud.
And yeah, and offset the fraud. They must pay for the canopy. They must or face the action, the fraud. If they deny the fraud, they must face that action in this tribunal. And then if they say there's an overpayment or a retention that's due to them, they must bring that accounting exercise in the High Court. And
Yes.
now, milady, in relation to the Caledon River projects matter, the counterclaim was related to the exact claim brought by the SIU. It was the same cause of action. The SIU brought an application to set aside the contract concluded by Public Works in Caledon, that contract. Caledon then brought a counter claim for an order that the vested rights in terms of the invalid contract remain vested. It's the same cause of action. Here, we're dealing with something totally unrelated. We're claiming a fraud, whether we're right or wrong on the fraud. Their counterclaim is, well, you know, there's an overpayment. We've done 13 other certificates and we helped you spend your budget. So that's the response to the point on jurisdiction.
Yeah.
Milady, on the point of we're not relying on the certificate, but the invoice at page 00480, which we say is prescribed. That's my submission on the issue of prescription.
Thank you. Are those then basically your submissions?
Yes, my lady.
All right. Thank you. Yeah, I think the other point was covered that I had initially raised with Mr. Glendinning. Yeah, that's it. What remains is for me to get those supplementary heads of the defendants and possibly the case, especially the SCA case that Mr. Glendinning has referred to, the 2021 case, but I'm sure Ms. Mashatisha will attend to that and have that forwarded to me. All right, gentlemen, if those are your submissions, I have to then consider them rather carefully and I will deliver judgment as soon as I'm ready. Judgment is reserved. Thank you very much for your efforts and for being crisp and short and to the point, and concluding this hearing in record time. Thank you very much. And we can take the adjournment now.
Thank you.
Thank you.
Bye-bye.